Hello, everyone. Welcome to our next webinar. And thank you very much for your time. I know it's not easy time for everyone. We are doing home office and different kind of activities that to contain this difficult situation. But today we will do your time very profitable in regards to data protection and coronavirus pandemic. Therefore, thank you very much for being us. And I would like to before going to my presentation, I will ask you to send your questions to use the Q&A button on the bottom of this window anytime during the presentation. And after the presentation, me and Baroum Mrad, we will answer all your questions on live. Please be active and stay tuned. Right now, I will start our presentation and then we can go further for our program. As you know, the topic of today's is data protection during the coronavirus pandemic, which is very sensitive time and sensitive topic that we process employee data, we process patients data, and we will try to give you some insightful from the practice, from the legal side, that what we are going to face in near future. The agenda is the first, I will talk a little bit about the lawfulness of the processing. Then I will explain a little bit from GDPR perspective point of view and the Civis Data Protection Act point of view, the privacy principles. Then we have several fast asked questions and answers for you. Me and Baroum, we will answer for it. Then you're welcome to ask your question for live Q&A session. Me, I'm Samir Aliyev, DPO Data Protection Officer Program Director at the University of St. Gallen at the Executive School. And today I will host Baroum Mrad, who is the DPO of Cantonal Hospital of Ticino, and he is also a data scientist. And we will try to make this session very fruitful for you and for your colleagues, if there's someone next to you. First, we will start with lawfulness of the processing. What does it mean? That means that today, a lot of governments and private companies, they try to help each other to contain and spread and mitigate the effect of COVID-19, which is widely referred as a coronavirus, as you know. Many of this stuff will involve processing of personal data, such as name, address, workplace, travel history, also health state of the employee and the visitors. So data protection law doesn't stand on the way of provisions of healthcare and the management of the public health issues. In many sources, they show that the data protection is the barrier for processing personal data in the hospitals, but it's not so. The measures are taken in response to coronavirus involving the use of personal data. Of course, in this moment, we have to respect the privacy of the patients and the employee. And decision in this regards should be informed by the guidance or directions of public health authorities or relevant authorities in different countries. In Switzerland is the healthcare authority in Bern, and organizations should have also regard the following obligations like lawfulness of processing. What does it mean, lawfulness of processing? Under the GDPR General Data Protection Regulation and the Civis Data Protection Act, we have several legal bases to process personal data. For example, when processing necessary for reasons of substantial public interest in the area of public health, then there are several legal grounds for it. We need to rely on legal obligation, not a consent, if we process data under the coronavirus, relating to coronavirus. So first, I would like to go in this moment. Let me be sure that you see the presentation. First, I would like to talk about the employment context. If we process personal data under the employment law or national law, it might be necessary for compliance with legal obligations to which the employer is subject as its obligation related to health and safety at the workplace, or the public interest such as control of diseases and other threats to health. That's legal obligation of the employers to process the personal data, especially the health data. When we talk about the legal obligation to protect the employers, to protect their employees' data, it's also the national law. It's not only the data protection law or GDPR. They have to also look for the advice from employment law, another national law, like in Switzerland, Epidemic Act. Under the GDPR, Article 9 give us the legal basis to process personal data, which should be necessary and proportionate to do so, including health data that we process. Any data that's processed must be treated in a confidential manner. That means that we cannot just disclose data for anyone in an emergency situation to process it, or any communication to staff about the possible presence of coronavirus in the workplace shouldn't be generally identify any individual employees. After this one, we have next context is public health. We will come to this point later on with Baroum, but what I can share with you here that the public health authorities may process personal data during the epidemic situation and pandemics in circumstances where the organizations are acting the guidance and public or direction of public health authorities. And GDPR also permit to process personal data, but there are several circumstances we will come into later. We have to look for certain principles like limitation on access, data minimization, confidentiality, accountability, and all those processes will be implemented even during the pandemic. Next context is the processing of mobile data. That means that the location data, and now many governments, they are processing our location data via our mobile communication devices. That means that if we go outside, of course, government will follow up. I don't know in Switzerland, but in many other governments, they do this one. And in Europe, they have to take care of the confidentiality. They have to follow the e-privacy directive, what's saying and respected. In the practice, location data can be only used to operators when made anonymous or with the consent of individuals. That means that if you process mobile data, and it should be the anonym, or you have to get consent of the individuals. That's the must under the e-privacy directive. Also, directive says us that the legislation measures to safeguard public security. That means that it consists in necessity, it consists the appropriate and the proportionate measures within the democratic society. Also, European Court of Justice and European Court of Human, they have the right to control all the mobile tracking regulation by the national member states. In this case, in the case of emergency situation, it shouldn't be strictly limited to duration. It should be strictly limitation of duration of emergency. That I will touch this point later on with a question. The transparency is one of the most important principles of data processing. If healthcare authorities or employer or governments, they process data during the pandemic, they have to inform data subjects. They have to be conscientious. They have to tell what they are doing, their purposes, and the retention period, how long they will keep personal data, how long they will process the data for a specific purpose to contain and mitigate the effect of COVID-19. That should be via privacy notice, that should be via the online privacy statements kind of stuff that should be implemented. In this case, the roles of DPOs are important to be transparent their data subjects. Next one is the confidentiality. Confidentiality is a part of the culture, Swiss culture, as we know, the bank secrecy, all the stuff. Since many years in Switzerland, it's the most respected area, the confidentiality. In this case, the public authorities, healthcare authorities, they process the personal data. We have to, or they have to ensure the security of data. They have to have proper access management. They have to have the proper password management and integrity, that it should be available to doctors. It should be available to public authorities, healthcare authorities, and the government, but in a manner of the confidentiality. Also, if you process the personal data to contain the COVID-19, you have absolutely third parties. Third party means that the companies, they process data on behalf of you, on behalf of the hospitals or governments. In this point, you need to have proper documentation or proper agreement with all those third-party management, third-party service providers, to ensure security, confidentiality, and integrity of the personal data, especially healthcare data. As you know, under the GDPR, we are prohibited to process special category of data, Article 9, but in certain cases, we are allowed to process personal data, the special healthcare data. In this case, data minimization is also playing important role, which is that we have to collect and process minimum necessary data. We cannot ask the patients the family's health situation, maybe the travel history of their family members or their colleagues. We have to pay attention which kind of questions we are asking. Last week, I was visiting the medical center in Zurich, and the clinic, they tried to ask me 5 pages of healthcare data, which is related 5 years ago, and it doesn't help them to contain the coronavirus today. I have to give my travel history last 6 months or 1 year. I have to give them my last contacts if there is anything related to the infected people or individuals, but I shouldn't give my health data, which was occurred 5 years ago. This is the data minimization. In this case, we have to respect the privacy, and we have to implement the measures to prevent COVID-19. Then we have the accountability. Accountability is mainly related to the documentation. We have to ensure that the DPO of the company or the responsible person or the management of the company, they ensure the accountability. They have to be sure that all the process related to coronavirus is documented. Here we are going to talk about record of processing activities, ROPA. We are going to talk about data protection impact assessment, which we will see the risk, which we will see the likelihood of the processing, the risk appetite of our processing, and that will help us to mitigate our risk, the privacy risk in the future. So maybe the Baroum, you have something to do on this point in accountability, the documentation, because as I know, daily you process personal data, and it's part of your work right now at the hospital to mitigate the privacy risks.
Yes. Good afternoon, everyone. Thank you again, Samir, for the presentation so far. Just really quick regarding the accountability. It's extremely important to have the processes in place during a pandemic, because things could change, and definitely focus on a specific DPI conducted on the process of obtaining data for COVID patients, and take accountability for everyone involved in the process of processing the data. So a DPI should help for sure.
Thank you very much. After short introduction of principles and the lawfulness of the processing, I would like to mirror some fast asked questions and answer them live. And many of the colleagues or clients, they ask me that if there is any guidance in Switzerland, special guidance on data protection. No, there is no official guidance by Federal Data Protection Information Commissioner right now. The Swiss Data Protection Act is in force, even during the COVID-19, prior to COVID-19, we have to follow up the Swiss data protection law. Also, if you process the individuals in the European Union, you have to follow the GDPR, what GDPR says in the related to personal data processing. But under the Swiss Data Protection Act, the health data are particularly valuable, and we have to protect them, may not obtain the private parties, by private parties against the will of the data subjects. And the processing of health data under the Swiss data protection law must be proportionate and purpose specific. That means that we have to have proportionate measures to implement when we process personal data, and we have to have the specific purpose for it. Where possible, appropriate data on flu symptoms or any other temperature kind of stuff as a fever should be collected and passed on by those affected themselves. It means that if we collect the data of the individuals or the visitors and employee, we have to inform them our purpose. And the collection of the further processing of health data by private third party must be disclosed to data subjects so that they understand the purpose and the scope of processing, as well as its content, time frame, how long they will process data and how long they will keep their personal data in their database. Also, processing medical data such as body temperature must be kept minimum necessary. As I told you, data minimization principle, we have to keep it minimum necessary, that data must be deleted once pandemic has ceased to exist at the latest. After the pandemic, we have to delete all the data that we collect related to contain COVID-19.
Samir, yes, so, really quick on this, what you said is absolutely correct for any employer and private companies. When it comes to a hospital, there is also a federal law, the law on epidemic, Section 2, Article 58, all the way to Article 69. They specify how public authority, government, and hospital now are under this legislation in order to process the data for the public health and to share the data with those who are authorized to receive this type of data. So you can receive the statistic, and you can also control and mitigate the spread of this pandemic. So it slightly changes when it comes to a public government or a hospital, the processing of this data under Swiss regulation.
Thank you very much, Baroum. Also, the employer, they have an obligation to ensure the health and safety of their employees. Therefore, it's duty of care and which requires them to know about potential contradiction of COVID-19 in their organizations. That's the legal obligation of the Swiss companies to collect and report symptoms of COVID-19. But once the employee knows that an employee have a potential contradicted COVID-19, they can inform other colleagues in the company, but the employer are not allowed to announce the identifiable names of the infected employee. That means that we have to inform our colleagues, but we shouldn't disclose the name of the infected colleagues to other employee. That is the strictly confidential information. So Baroum, I have a question for you in this moment. Can an employer lawfully impose temperature and blood testing for COVID-19 for employees and the condition that to let them enter the workplace? Is it possible, or is it
with the consent of the employee, which in this case will become a patient if that's necessary? But an employee cannot ask medical data, can ask the employee to go to a medical facility like a hospital, get those information taken, and with the consent of the employee sharing this information. But I don't see that how that could be necessary, like you said, in data minimization to an employer to know what the temperature level is of an employee. What they need to know if it's a problem for the security and safety of the rest of the employees.
But as I know, the Swiss government has stated that publicly there is no necessity for general COVID-19 testing for employees. That the employer, they shouldn't test all the employee because of COVID-19. If they do so, the general testing, then they have to have the justification They have to justification for this to do so. And the general public test kits are not available for everyone. It's prohibited to sell in the market. But saliva or blood testing must be done by qualified medical centers, unless authorized otherwise by Swissmedic, which is public authority in Switzerland. In this point, I want also the touch one point, the international transfer of personal data. Once the hospitals, especially the private and the public hospitals, they collect the test, sometimes they share it internationally. They send the test results or to get the results outside of the Switzerland. In this point, so the hospitals or public health authorities, they have to pay attention for adequate level of data protection, that they can share those data with EU countries and the European Economic Area countries like Liechtenstein, for example. But in this case, they have to have outside of the EU, you have to get standard contractual clauses. But once you send pseudonymized data or non-identifiable personal data on the test kits, there is no need for standard contractual clauses for international transfer. Baroum, have you ever done the international transfer of personal data related to COVID-19?
I have, yes, but in this case, for related to COVID, first of all, if there is any transfer to international authorities or organization, it's done with an anonymized manner, so we don't share the personal data of the patient. You shouldn't share the personal data of the patient. If you do, it has to be done to those authorities who are authorized to process such data. But again, we at the hospital, we don't share the data internationally. We share it with, as per the law for Article 58 of the law of epidemic, only to those authorities like the canton, and then the confederation would take over, and they might share data with other international authorities. So that it's important so that people know what the status is with the bordering countries. We directly don't do it unless it's anonymized or a graph or a statistic.
Mm-hmm. Thank you very much, Baroum. The next fast asked question is, can the employer require all the staff and the visitors to the office to fill out a questionnaire requesting information, their medical information like temperature, like they have touched with another infected people, or their travel history? Here again, we have to implement proportionate principles, and we have to collect as minimum as data is important for us to identify the people, to let them inside the workplaces. But as I mentioned before, employer, they have legal obligation for safety and health situation of their employees. Therefore, national law, especially employment law, will place important role for this process. We have to collect minimum data, we have to be proportionate, and we have to have confidentiality for it. We cannot just keep the data for 5 years, 10 years. After the pandemic, or after the process is done, our purpose is done, we have to delete all the data. Next question is about a medical certification. Now, we have heard that several employers, they ask their employee to give them a medical certification in light of the situation to COVID-19. While employers have a legal obligation to protect their employees, they care to protect their health and the health of any other persons in the workplace. In this slide, employer would be justified in requiring employee inform them if they have any medical diagnosis of COVID-19 in order to allow necessary steps to be taken. Any comment from your side, Baroum?
Yeah, it can be done. Like you said, it's for the safety of the rest of the employees. So an employer can request information. I wouldn't say specific. They should stay as neutral as possible. This is also to avoid discrimination of that certain subject. But they can definitely ask and find out if the diagnosis or the result will be positive, or simply if the symptoms are present And if anything, in order to not discriminate, they should advise the employee to stay home for that duration of time. The other thing is, even if they do collect the medical certificate by explicit consent of the employee, they should do it in a very safe and structured manner with confidentiality, of course.
It's also important to keep in mind that the recording of any health information or specific category of data must be justified and factual, must be limited to what necessary in order to allow the employer to implement health and safety measures. It should be always proportionate, it should be always confidential, and it should be minimum data in order to implement data protection laws and regulations.
Yeah, and usually even the information you get are not that detailed from a doctor to an employee, to an employer.
Yep. Yeah. So the next ask questions about the monitoring of the citizens to contain and mitigate the spread of COVID-19 by governments. The governments should first seek to process location data in anonymized way, as I mentioned before. That means that processing data aggregated in a way that individuals cannot be identifiable or cannot be identified, which could enable generate reports to concentration of mobile devices at a certain location. As a government, you cannot just track all the locations or other neighbor countries location. It should be on a certain location. It should be anonymized, and it should be on the. They have to have the retention period, and absolutely after the pandemic situation, they have to stop to track the citizens, to track their mobile and the metadata. That's from my side. And my next question would be related to Baroum. Does the processing of health data by health authorities, especially for public hospitals, open the door to surveillance by governments or by hospitals? What's your opinion on this?
There's definitely, I think, right now a fear, if you want, of the so-called surveillance state, because government are under the obligation right now to collect data, to do a form of surveillance, but that's in service of the public health. So I understand that there could be an open door to the so-called surveillance, but again, there is a pandemic, but all law and principles of data processing and privacy are not changing. They should stay, they are as they were before, they are during the pandemic in place, and they should stay even after. And I think transparency will become a big key player when it comes to private company or government taking over these data.
So that means that there should be limitation on this, and they have to have specific regulation or guidance just for pandemic. Absolutely. No surveillance allowed. Good. Yeah. I hope it will be so as we discussed, but the time will show us what's coming next. And my next question to you is related to employee of hospitals. You are a data protection officer of a public hospital, and you are processing a lot of patients' data relating to COVID-19. And I would like to know a little bit about data subjects access right and the legal obligations that you are using right now. It's vital interest or legal obligation, another legitimate basis for it, and the confidentiality, how to ensure the security of your patient's personal data. You shouldn't give any sensitive information, of course, but this is general information which could be helpful to our auditorium right now.
Yeah, so as a Swiss hospital, or as a hospital, you have in mind always the care of the patient first. So everything for us in general, everything stays the same way it was. The privacy and the confidentiality and the data protection of the patient as it was before. In this case, now it's incremented because it's a pandemic. So what we do is a very quick and specific DPAI on the process of obtaining data and identifying a patient as a COVID patient, for example, and possible COVID positive patient. So we explain, and you have to be a little bit more explicit than usual with the data subject right. So you have to really be transparent and inform them the reason of the collection. Although that is becoming more clear now when it's a hospital. We don't change much when it comes to the processing or safety and policies and security and technical measures are taken into account as before. And the legal obligation go again with the same federal law that we discussed before, and we touch into the confidentiality. So we have the legal obligation to process because we need to take care of the patient and the population around it. So even for isolation, even for keeping patient in certain area, even to understand our employee who came in contact with these patients, but everything is processed in a manner for the public safety and the safety of the employees. And that's
Very
again,
good.
Article 58. And the confidentiality is the one that we share only what is necessary with government authorities only.
Thank you very much, Baroum. There is a very interesting question, and it's also for the future. After the pandemic, what we are going to do and how we will implement new measures to restore privacy management, especially in healthcare. As you know, you change all the process, you change all the working rhythms, and there will be new implementation after pandemic, sure. And as before you mentioned that pandemic plan, would you like to explain us a little bit about this?
Yeah, I think right now it's quite clear that everything will change, in particular for public health organization or healthcare organization in general. It's been clear that in many ways everyone wasn't as prepared as they should have been with the approach of the pandemic. But there's a lot of lessons to be learned, and we highly recommend. I personally highly recommend focusing right now on what is a pandemic plan. If you didn't have one, start creating one, and in there simply focus more on the clinical part of the pandemic plan. There are very clear guidelines at the federal level. But when it comes to data protection, make sure your policy is allowed to implement them right away when a pandemic is in place, such as working from home, processing data from across border, and so forth. And at the end, the most important phase, because we do go back to the normal or a new normal, is to have a post-pandemic plan. So the restoration of normality, which includes your data processing, a new DPIA in place, and so forth. All the policy have to be restated, the one if they were taken over by a specific policy under the pandemic, but it's important right now to focus on that phase.
Do you have any specific policy for retention? Do you have, is there any plan or for the future to have retention policy?
Retention of data?
Mm-hmm. Yeah.
Yes. So for hospital, it's obviously a little bit different than a private organization, but hospital have a requirement, which is by canton under the law, to keep data for 10 years, will become 20 and so forth. Under a pandemic, there's a different level as well, but it's all specified in the law. So our policy is based on what is legally obliged to be done.
Thank you very much, Baroum. And it was really helpful from my perspective, and I hope it was also helpful for our audience. From that moment, I'm going to jump to Q&A session, live Q&A session. I see that there are many questions we have. It will be nice if we answer all the questions together next 20 minutes.
Let's do this.
Let me stop our presentation right now. So first question is, I need to open first, yeah. I'm a bit surprised that this meeting is being held via Zoom, even though Google has banned Zoom due to data privacy and security issues. Yes, it is via Zoom, and we see every day different news on the Zoom, the privacy issues of the Zoom, but they react very fast. They implement very good, very intensive privacy solutions for their tools. Right now, as a university, we are using Zoom, even though Google or other the corporations, they banned to use them. The next question is about, will the doctor certificate simply state whether fit or unfit to work, or therefore take the diagnosis into account in this assessment.
Yeah,
And
that is
hence,
correct.
details are not necessary for the employer.
Yeah, that is correct. Usually the doctor's note simply states if it's fit or unfit. It doesn't go into clinical details. It shouldn't go into clinical details. That is not necessary for the employer.
Thank you. Next question is coming from Annaleta. How does the dependence of the employee play in regarding giving consent when the employer wants to know about his or her health data? This is not giving the consent may lead to the dismissal. From my perspective, employees shouldn't look for consent if they have a legal obligation for the health and safety of their employee. In this regard, the employer can collect health data to protect their employee in the office, in the workplace.
Again, be transparency, key principle. Be transparent with your employees and ask them.
I will go to Q&A session. The other question right now, just a moment. Give me time, please. When we work from home, of course, there's always. I assume a recording video call recording the conversation, right? I assume recording of video calls, for example, job interview requires consent for the participants in the conversation, right? Yes, of course. Absolutely. If you have a job interview, they record it, they will collect your consent. And we inform you that our webinar is also recorded, but there is no identifiable data of our audience to the public. Yep. Would you advise HR, a large companies, over 1,000 employees, to conduct a DPIA on COVID-19 process of their employees' data?
Absolutely. Absolutely. We do it under the pandemic to understand if there is a new process in place or if it's required. So yes, absolutely, I would advise to be specific though on the process of COVID-19.
Thank you. GDPR doesn't apply in Swiss healthcare system. That's true. Swiss is in Switzerland. Why does everybody talk about this in this context? Why we talk about in this context? Because the GDPR is a international modern standards for data processing, and there are some points or principles that Swiss Data Protection Act doesn't cover, and it is good practice for Swiss companies to implement GDPR's principles in their daily business and the data processing, that they ensure the security and the privacy of their customers and employees. The next question is, I do not quite understand the relation between the minimization of data and the containment and the spread of the COVID-19. Could you explain a little bit more?
Yeah, so what I think he's asking is the relationship between taking only the necessary data that you need, but that was in relation to private entity and other organization. As a healthcare organization, we take into account every data possible. The processing should be done for everybody in general with the scope and the minimization in mind, meaning you don't need to process things that are not necessary. As a healthcare professional, we take all the data that is necessary, and that will help with the containment because we can identify the number and advise government on measures that should be taken or could be taken to contain.
Thank you very much, Baroum. If you have a medical history placing you in the high risk group, data from 10 years ago might be specific in COVID-19 context.
Yeah, which is a typical case. So absolutely 10 years ago, 6 years ago, 5 years ago, any condition you had could be relevant. So, but this is an implicit and explicit consent when a patient comes to the hospital. It's being taken into care. That's the priority. So the doctor has access under his own legal authority.
But those kind of data should be collected only under the healthcare authorities, not just for employment perspective, because it doesn't relate to employment law or employee safety and health that you have a medical problem 10 years ago. That's
not for private companies.
no, not the
Only for
private
healthcare.
companies, only for public health and private
Yeah.
health, of course. The next question is, what role tasks do you see for the data protection officers during business continuity management, and how should the data protection officer prioritize consulting, monitoring of compliance of their job?
That's also a very good question. Yeah.
That's a very good question. Data protection officers, they have huge role during the pandemic because they are the key point for all the business. They are key point for HR, for doctors, for processing and third parties. And to manage the pandemic, to contain the COVID-19, it is related directly to persons, patients, and the individuals and their data. That's why we have to be careful when we advise to our business, when we advise to our doctors and healthcare employee. Baroum, would you like to tell something about this? Because
they asked about
of
business continuities, and obviously focus on a business continuity in the sense that you can mitigate eventual risks of privacy and data processing, conduct, if possible, peripherally assessment, verification that there are no current privacy breaches or data breaches, and then always check with your information security officer, with the IT team, about all the cyber security issues that could be taken into, they should be taken into account during this pandemic. Absolutely. So it's a huge role that has to multitask between different specific professionals within the organization.
Mm-hmm. Thank you. Do you work with anonymized data or with pseudonymized data? So anonymized and pseudonymized data, they are different type of data. It depends. If you process send data international, it's better to anonymize or pseudonymize them, that it will not be identifiable. Or if the governments, they process data, it should be also anonymized from operators, telecom operators. But it depends really on your process, for which purpose do you use data and whom you disclose the data. Yeah. The next question, thanks for your webinar. Could you please give us some advice, guidance for data protecting at new installed home office home workers?
Yeah, just imagine a huge question everybody's asking these times. This goes between IT security, so with your IT team, obviously, if you're talking about bringing your own device, if you have your own devices, it depends what the infrastructure is that your IT team put in place. If you're connecting via VPN, if you're connecting remotely, all policies that you had before, if you didn't, you should have some. All the policies that you had before for working from home should be implemented. And the security measure I would advise is constant awareness to your employees on the type of Wi-Fi and network they're connecting to, what they download or print at home, which they shouldn't do. The type of, specify very clearly, working from home, what is allowed in terms of processing personal data. Business continuity is important, so you have to be very specific in your work from home policy. And the setup of the business of the home office should be focused primarily on the privacy of the data of your company and organization.
Thank you very much, Baroum. Also, the employee or people or our colleagues, if you are working from home, you have to be careful with phishing attacks, because cyber attacks during the corona pandemic increased 5 times, 6 times more. The hackers, they try to steal your credential, your private and sensitive information, especially they send you the information, phishing news related to coronavirus, corona map, latest information. Please do not click any unknown resources, any unknown emails, just delete them and don't forward or click any files that attach there. You have to be careful, you have to stay safe during coronavirus. Thank you very much. If the company takes employees' temperature, asking the employee for consent is sort of moot point. Since an employee wouldn't be given this freely due to the employee or employee relationship, or how do you see this one?
First of all, if you're not a healthcare organization or public health, you should not take clinical data or like simply like a temperature of your patient, of your employee. It makes not much sense. If you do find a situation like this and you are exposed to it, which could happen, then employer says, I would like to take temperature, everybody should be freely given in the real sense of it, meaning if I don't want to have my temperature be taken, I should not. And then you process only the data of those who are willing to take it. Some
Actually,
people
employer shouldn't seek the consent of the employee because it's a legal obligation to ensure the safety and health of the employee at the workplace. Therefore, the employers will not seek any consent from the employees. We have the last question here. I cannot see how consent in the context of asking for health information from employee is even appropriate or valid. We just answered this one. There is no need for consent. The legal-based process has stated that private company is legal obligation of the employee. So that's all questions we answered for today. And I would like to thank you, Baroum, for your time. I know you are super busy at the hospital. You help your doctors, our healthcare colleagues. Thank you very much for your time. It was really insightful information we shared our community. Hopefully it was also helpful for the people. They joined us online. And please stay tuned. We will have more webinars and insightful information on the profit of the community, and stay safe. Thank you very much, everyone.
Thank you, everyone. Thank you, Samir.
Many thanks. Bye.